Hello, everyone. My name is Peyton Geiger. I'm a computer science major here at Auburn University, and today I'll be presenting on major Supreme Court cases that have shaped the field of computer ethics. As technology evolves, ethical scenarios and issues around privacy, speech, and copyright become much more complicated, and these cases help us understand how the law tries to keep up with those changes. So basically, the way that I broke these down um, this presentation down is I'll go over the case, just kind of brief summarization, I guess, of the case. Um, then I will basically agree with one side and kind of give reasoning behind that decision. And a side note from that would be that this is an ethics course, and what I found in obviously most ethics courses, I'm sure everybody else knows, is everybody has their own opinion, and I'm not here to tell you that you're right or wrong. I can only just give you my opinion on each one of these, and um, yeah, it's up for you to formulate your own opinions on these cases. That's why they're public, I feel. So yeah, that's gonna encompass what we're talking about today. Oh, and the last portion of that is going to be going over who won that case, and then what has changed, whether that be in law or common practice for these cases. So here's a list of some of the cases that we're going to be going over today. You're going to see them, so I don't really need to hold this slide up too long. But the first one we're going to go over is the Katz case. Katz versus United States. This was in 1967. It completely changed how the Fourth Amendment applies to privacy. Charles Kantz was making illegal gambling calls from a public phone booth. The FBI recorded his conversations from outside the booth without a warrant. The government argued that since he was in a public place, he had no privacy. But the Supreme Court ruled that the Fourth Amendment protects people, not physical places. This created the well-known Katz test, which asks whether a person is expected privacy or whether society views that expectation as reasonable. This case became the foundation for all modern digital policy and privacy law. To summarize another few key points, the Supreme Court declared the Fourth Amendment protects people, not places, as stated earlier. Major precedent for electronic services, wiretaps, and digital privacy cases. It was only Justice Black that dissented, arguing that the Fourth Amendment only protected tangible property. Um, where I stand on this case, I chose to side with the respondent, which in this scenario was the United States. This case demonstrates clear violations of the Fourth Amendment, but law enforcement should be able to breach the search and seizure regulations with reasonable suspicion. I know that is a controversial opinion, being that some people don't believe that the government should be above of the law, and I don't necessarily agree with that to a certain extent. I think they're held to a higher responsibility, and therefore um, they should have certain leniencies within the Constitution that ultimately protect and make a safer, country. The old saying, and I put it down here, is if you don't have anything to hide, why should wiretaps be a concern? I changed the last part of that, but you know what I'm trying to say. Personally, I don't mind law enforcement stepping into my Fourth Amendment protections if it means increasing safety for me and the people around me. I hold this perspective specifically when it comes to government agencies acting in the interest of public security. An entity, as I said earlier, outside of this, I would side with the petitioner in this case. We should place greater trust in the judicial system and its ability to oversee these actions responsibly. However, I do believe that a warrant should be required, since surveillance inherently conflicts with the constitutional rights from unreasonable searches and seizures. So, yes, I do believe that they require authorization through a warrant to be able to search and seize. So I do agree with that aspect, but ultimately I think that I side more with the United States in this case. Who actually won that case was Charles Cance himself. He ultimately won the case. This ruling expanded privacy protections and set the rules for how electronic surveillance must be handled today. It's why law enforcement needs stronger justification when dealing with digital communication. Some of the changes / impacts were that it established the reasonable expectation of privacy test for the Fourth Amendment protections. It expanded privacy rights beyond just physical spaces, which was huge at this time. It set precedent for electronic surveillance rules. So those are the changes. Next case that we're going to be covering here is going to be Sony Corp versus Universal Studios, 1984. Sony versus Universal is also known as the Betamax case. At the time, Hollywood studios believed that VCRs would destroy the movie industry because people could record shows at home. The Supreme Court ruled that recording a show for personal use, called time shifting, is considered fair use. So as long as essentially if you're using it in-house without the intent to distribute or modify this, then it falls under fair use. They also ruled that Sony wasn't responsible for copyright violations committed by users, which is also a big thing that I'm going to cover in this. Is whether or not they would be liable for any basic copyright breaches. The decision protected technology companies and allowed devices like the VCRs, DVD players, DVRs, and even modern streaming technology to exist. So this was a big case at the time, and really shifted like file sharing, essentially what it would ultimately lead to in today's case, like copyright infringement with file sharing. So some of the key points here was that they called time shifting was fair use. Manufacturers of VCRs are not liable for contributory infringement if the device has substantial non-infringing uses. So I think what it's trying to say here is if it was not made with the intent to infringe upon your copyright and it has other uses besides that, then it's not liable for any penalties. Precedent used in later digital and peer-to-peer file sharing cases boosted the home video market and established a framework for balancing technology versus copyright law. Dissenters feared any unauthorized copying, even for private use, violated copyright law. Whose side I stood on here was the petitioner. I stood with Sony Corp. This case raises the question of whether a new invention should be treated as a threat simply because it could be used in harmful or illegal ways. So this is a big topic of discussion. If something was invented with the use for good, should it be faulted for any bad that could come with that? So when Betamax was introduced, many copyright holders saw it as a danger because it enabled people to record and potentially distribute copyrighted material without permission. New technologies to come listed below were some, as I said earlier, VCRs, DVDs, VHSs. Copyright, here's where I stand on that, is that copyrighted works absolutely deserve protection, but we should not blame technological advancements themselves. Instead, it should rest on those who misuse these tools to commit actual crime. Sorry, I stuttered there. Who won in this case was Sony Corp. Sony Corp won this case, and the impact was huge. This ruling protected innovation in consumer electronics and laid the foundation for many technologies we use today. Without this decision, home video, DVRs, and modern digital recording would look completely different. Some of the changes and impact: court ruled there is no reasonable expectation of privacy for numbers dialed on a phone. They limited the Fourth Amendment protections in cases involving information voluntarily given to third parties, and they influenced how law enforcement collects digital data today. So some pretty big change. The next case is going to be Reno versus the American Civil Liberties Union. And this case was the first major Supreme Court case dealing with the internet. The Communications Decency Act tried to criminalize anything indecent online. The problem was that the law was extremely broad. It could have censored educational websites, medical information, art, literature, and discussion forums. The Supreme Court unanimously struck it down, ruling that it violated the First Amendment. This case did set the standard for protecting free speech online. Who did I side with? I sided with the respondent, which was ACLU in this case. Here are some of the reasons why I do agree with this with the union, which argued that CDA was far too broad in its restrictions. Educational content, websites that provided sex education or health information could have been censored because law enforcement banned indecent material, even though it was for learning purposes. Obviously, you can see that would be a negative. I mean, they teach sex ed in every school, so online should be no different. Art and literature, classic literature, poems, or art that included sexual themes may have been blocked online, even if they were widely accepted in schools or libraries. Medical advice, like sites giving advice about pregnancy, contraception, or safe sexual practices could be restricted, preventing people from accessing helpful information. I think the medical one in this case was probably the biggest one that stands out to me. Simply restricting, or censoring medical information because it could, be indecent material is not helpful at all. So, there are a few other things that a few other issues with it, but the law violated the First Amendment because it could have censored protected free speech, including educational content. The government should play a role in regulating the internet, but only in ways that do not violate constitutional rights. So the victor of this case was ACLU. Because of this decision, the internet became protected as a space for free expression. Some of the changes were that the broad provisions in the CDA were stricken down, and it confirmed the strong First Amendment protections for online speech. All right, next case here is going to be MGM versus Grokster. This case followed focused peer-to-peer file sharing. Grokster software allowed users to share music and movies, and many used it illegally. The court ruled that Grokster could be held liable because they encouraged copyright infringement. This introduced the concept of inducement liability, meaning if a company promotes illegal use of its technology, they can be held responsible. And I highly doubt that a company would put public the illegal ramifications of its product, but it's neither here nor there. Some of the points made here are that liability arises if a company actively promotes illegal use of its technology. Narrow application. This is very similar to the Sony versus Universal case. The decision had a major impact on digital file sharing platforms, effectively ending many services and shaping the legal landscape for technology and copyright law. It marked a turning point in peer-to-peer file sharing litigation, influenced subsequent cases like LimeWire and other digital copyright enforcement. The side I chose here was the respondent, which was Grokster. Similar to how I chose Sony, where new technologies like file sharing software created potential risks to copyright holders. Simply creating a technology that could be misused does not automatically make the creator liable. The focus should be on how the technology is actually used by consumers. I believe that individuals who knowingly violate these copyright laws, whether by copying, modifying, or distributing copyrighted material should be held accountable for their actions. The law should target the people committing the illegal activity, not the tools they use. That is obviously a bold statement to make, as it could like dip into other realms of law, but we're only talking about computers currently. So developers and inventors should not be punished for creating technology that has legitimate uses, even if they misuse it. Holding creators liable in these cases could stifle innovation and discourage new technological advances. So there are drawbacks. The victor in this case was actually MGM Studios. This ruling made it clear that companies can't actively promote illegal use of their products. It significantly shaped the future of file sharing services and copyright enforcement. It introduced, like I said, the concept of inducement liability for peer-to-peer file sharing, clarified limits of the Sony precedent, where technology with primarily infringing use can be held liable. Next court case here is going to be Riley versus California, where the police searched Riley's cell phone during an arrest without a warrant. They found evidence linking him to a crime. The Supreme Court ruled that police must have a warrant to search a phone because phones contain extremely personal digital information. This case expanded digital privacy rights and recognized that modern devices deserve special constitutional protection. This case right here, I find similar with some of the other cases as well, where the government entities are essentially bypassing the Constitution in order to protect. And in this case, they're seizing and searching without warrants and breaching the Fourth Amendment protection. So I stand similar to this case as I've stood on other cases surrounding the Fourth Amendment. I side with the respondent, which is California on this side. Like I said, this case was similar to Katz versus U.S. and the topic of new technologies being governed without violating the Fourth Amendment. It was important for the Supreme Court to take this case as there was a lot of unknown and inconsistencies within the state on search and seizure as it related to a cell phone. I make the same stance that it is indeed a violation of the Fourth Amendment for law enforcement to search your cell phone without a proper warrant. However, I do believe law enforcement should be exempt from this as a natural protector of public safety, whereas any governed agency should not receive the same exemption. Again, I hold the same truth where if you have nothing to hide from the government, you should have nothing to worry about. So in this case, the victor was David Leon Riley. This decision strengthened digital privacy rights and clarified that a cell phone is not the same as a wallet or a bag. It holds highly sensitive personal information. Today, police must obtain a warrant before searching someone's phone. So those are some of the impacts that it had. Is reinforcement on the Fourth Amendment protections for digital data. I stand on the same foot where if it's a government agency that's supposed to shield and protect, I have no problem with them breaching the Fourth Amendment. And that goes, with cell phones too as well. I know it holds a lot more information than any tangible object that we have around us. But that's just my opinion on it right there. All right, and the last Supreme Court case we're going to be covering today is Google LLC versus Oracle America. This was a Supreme Court case addressing whether Google's use of Java APIs in its Android operating system constituted copyright infringement. The court bypassed the decision on whether APIs are copyrightable and instead ruled 6-2 that Google's use of Java APIs constituted fair use. This decision focused on Google's use as transformative and necessary for software interoperability, and ultimately reversing the Federal Circuit's ruling. This case set a major precedent for software industry, clarifying how fair uses apply to functional elements of computer code. So this was a pretty big case. So the side that I chose in this case was with the respondent, which was Oracle America. Google used Java SE libraries, in my opinion, in its Android operating system without fully complying with copyright protections, which undermines the rights of the original creators, Sun Microsystems, which, as we know, was later acquired by Oracle. Allowing Google's actions to go unchecked could set a precedent for where companies freely copy software code without permission, discouraging innovation and investment in software development. Copyright law exists to protect intellectual property, and ignoring it for convenience erodes the incentive for developers and companies to create new, valuable software. Oracle, as the copyright holder, had the legal right to control its code as it was used, ensuring that creators maintain ownership from their work. Google was not trying to basically comply with that. They wanted to modify it and then distribute it for their own purposes. The victor in this case was Google, however. The decision clarified how fair use applies to software code and APIs, which impacts how developers build compatible systems today. It supports the interoperability of software, but leaves open future questions about parts of the code are copyrightable. Some of the changes were, like I said, clarified copyright rules for software and APIs, and influenced how software companies can use existing code without infringing copyright. And Supreme Court ruled ultimately that Google's use of Java APIs in Android was fair use. All right. So in conclusion of this presentation on computer ethics, what I've realized is that with computer ethics comes a wide variety and range of complex issues surrounding the responsible and ethical use of technology. Many of these issues are not black and white, and it can be difficult to take a fully one-sided position in Supreme Court cases because each ruling tries to balance competing values. For example, in situations where the government limits certain Fourth Amendment protections, I believe there are times where they should have the sovereign authority to intervene in the interest of public safety. Yet it is equally essential to recognize the importance of protecting individual rights and ensuring the government power does not extend beyond the Constitution, what the Constitution allows. These cases show how delicate the balance is between innovation, law enforcement needs, and personal freedoms in an increasingly digital society. As technology continues to evolve, courts are forced to reinterpret long-standing constitutional principles to apply them to entirely new contexts the original framers could have never have imagined. This creates a constant push and pull between public interest, corporate responsibility, and public personal autonomy. It also highlights why computer ethics is such a vital subject, that it demands that we consider not only the capabilities of modern technology, but also the moral and legal boundaries that should guide its use. The Supreme Court cases examined throughout this topic demonstrate how quickly ethical questions emerge, whether new tools, platforms, or communication methods are introduced, whether it involves privacy rights, copyright disputes, or free speech concerns. Each decision carries long-term consequences for both society and future innovation. And I think one of my biggest takeaways from this presentation and going through some of these cases is just how complex they kind of can be in terms of like not being able to really fully choose one side, because there are other aspects to the case that could go the other way. So yeah, that is my presentation.